He stood there under oath, calm on the surface, but every pause felt like a wall going up. The man who once demanded the release of every secret file was now refusing to answer the simplest question. It wasn't just what he said that caught everyone's attention, it was what he didn't say. The silence was louder than the words. And in that silence, you could feel the weight of promises breaking. Because when power hides behind legal language, that's not transparency, it's strategy. The hearing began like any other, but it didn't take long for the tension to cut through the room. Questions came fast, direct, clear, impossible to misinterpret. Are their names in those files connected to powerful people? Instead of a straight answer, there was hesitation, deflection, and long explanations about court orders and protective filings.
He provided a birthday card with the shape of a woman, his clear signature for anyone who actually looks at it, and references a secret. In 2004, the FBI initiated an investigation into Jeffrey Epstein. I would like for this committee to request from the FBI the opening document, the report of investigation that would have initiated the investigation into Jeffrey Epstein in 2004, because I think we should know how that investigation began. We know that President Trump had a falling out with Jeffrey Epstein around that time. Was it President Trump who provided the FBI with the information that caused this investigation to be opened? This committee deserves to know that. I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Maryland.
Thank you, Mr. Chairman. I want to follow up on the excellent points made by the gentleman from Florida and from New York. Let's try this again. I've got an amendment at the desk.
Gentleman from California reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 4371 offered by Mr. Raskin.
Without objection, the amendment will be considered as read. The gentleman from Maryland is recognized to explain the
amendment. Mr. Chairman, thank you, ensures the release of all files associated with Alex Acosta in the Epstein affair. The gentleman from New York focuses our attention on the fact that this was being investigated back in 2004, 5, and 6. And in May of 2007, an assistant U.S. attorney working for DOJ prepared a draft 60 criminal count indictment against Epstein. 60 criminal counts: statutory rape, solicitation, human trafficking, conspiracy, and so on. They had a very comprehensive and complex understanding of what Epstein was doing, how he was funding it, who was involved in it. And just 2 months later, Epstein's attorneys met with the U.S. Attorney for the Southern District of Florida. That U.S. Attorney would later become famous as Donald Trump's Secretary of Labor. But at that point, he was leading the investigation, and he offered to end the investigation and throw away those 60 federal charges completely if Epstein would plead guilty to the state charge of solicitation. Now that has got to be the sweetest, coziest, sweetheart deal ever made by a federal prosecutor. They've got this guy dead to rights on 60 criminal counts of running a comprehensive child sex trafficking conspiracy, an international one, for those of you who are sticklers for materiality and relevance, an international child sex trafficking ring. And they gave it all away. They accepted a short jail stay for him. So what did he get to do down there in Florida? Well, he pled guilty and he got 18 months in a minimum security facility. He was allowed to leave for 12 hours a day to work at a foundation he founded, and apparently continued doing exactly what he was doing before. And I don't want to be too graphic and lurid because there might be kids watching, but he was doing precisely the kinds of things that we're talking about in terms of the protection of children. He was violating children, violating young women, and then he would go and spend the night in jail. And in the meantime, he was able to bargain immunity for all of these other people who were working for him.
The gentleman yields.
Yes, by all means.
In other words, while he was doing all the sexual predation, the government was providing room and board and meals and making it cheap of him to do so.
Well, that's not a bad way of looking.
Gentleman yields back.
Mr. Chairman, I have a unanimous consent request.
Gentleman's recognized.
So I've got 4 documents I'd like to introduce into the record. The first one is Jeffrey Epstein's 6 story played out for years in plain sight. And Acosta is quoted in here saying, "I was told Epstein belonged to intelligence and to leave it alone." The second document is entitled, "What Epstein's Bodyguard Warned About His CIA Connections." The third document is from Fox Digital. It's titled, "Epstein's Private Calendar Reveals Planned Meetings with Obama Admin Official CIA Chief." And the last document is Wall Street Journal article that highlights Ehud Barak's 36 meetings with Jeffrey Epstein. He was the former Prime Minister of Israel and head of military intelligence for Israel. It may have held that title when he met Epstein, and then, yes.
Without objection, the gentleman will hold for a second. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. Just one UC request. This is Judge Engelmeyer's decision from August in U.S. versus Epstein, stating the government's 100,000 pages of Epstein files dwarfs the 70-odd pages of Epstein grand jury materials.
Without objection, the gentleman from Kentucky is recognized for 5 minutes.
Thank you, Mr. Chairman. Director Patel, I watched some of your Senate hearing yesterday when Senator Kennedy asked you, "You've seen most of the files. Who, if anyone, did Epstein traffic these women to besides himself?" You replied, according to the transcript, "There is no credible information that he trafficked them to anyone else." You also said somewhere in the hearing and here today that the problem is that the case files are constrained by limited search warrants from 2006 to 2007 and that the non-prosecution agreement hamstrung future investigations. Those constraints only apply to Southern District of Florida. They do not apply to Southern District of New York, the location of the 2019 sex trafficking indictment, which produced many things, including a series of FD 302 documents. According to victims who cooperated with the FBI in that investigation, these documents in FBI possession, your possession, detail at least 20 men, including Mr. Jess Staley, CEO of Barclays Bank, who Jeffrey Epstein trafficked victims to, victims including minors, such as Virginia Roberts Giuffre, may she rest in peace. That list also includes at least 19 other individuals, one Hollywood producer worth a few $100 million, one royal prince, one high-profile individual in the music industry, one very prominent banker, one high-profile government official, one high-profile former politician, one owner of a car company in Italy, one rock star, one magician, at least 6 billionaires, including a billionaire from Canada. We know these people exist in the FBI files, the files that you control. I don't know exactly who they are, but the FBI does. Have you launched any investigations into any of these people, and have you seen these 302 documents?
Sir, I have asked my FBI agents to review the entirety of the Epstein files and bring forth any credible information. And we're working with Congress not only to divulge that information and produce it to you, but any investigations that arise from any credible investigation will be brought. There have been no new materials brought to me launching a new indictment.
So is the loophole here, or is it your assertion that these victims aren't credible, that the 302s maybe didn't produce credible statements that rise to a probable cause?
It's not my assertion, sir. It's the assertion of 2 different United States attorneys' offices from 3 separate administrations who investigated those same materials in lifetime.
Are the 302 documents in the FBI's possession?
They reviewed all that, yes, sir.
And so have you reviewed those 302 documents where the victims name the people who victimized them?
If I personally know, but the FBI has.
So how can you sit here and in front of the Senate and say there are no names?
I said
I named one today.
I said we are not in the practice at the Department of Justice and FBI of releasing victims' names. That is not what we do. We are also not in the habit of releasing incredible information. That's not what we do. But multiple authorities have looked at the entirety of what we have.
Okay, I got to move on here. Were you present when the AG had the White House event when she released the binders to the social media influencers?
I was, yes.
So if you're willing to meet with social media influencers who stood to benefit from the sensational and sad stories of these victims, will you meet with the victims as well?
The FBI will meet with anyone who has new information.
Will you personally meet with them?
The FBI and the professionals who are handling the cases will.
Were you instructed that it was important to release the documents to the Oversight Committee on the day of my introduction of the discharge petition to release these files?
I don't know what day that was, so no.
Well, they were released that day, and there were victims' names who weren't redacted because they were in such a rush, and the victims are not happy about that. Have you investigated any of the CIA connections? Have you seen the CIA file on Jeffrey Epstein? And if you wanted to see it, would they show it to you?
Well, I can speak for the FBI, and that's presuming there's a CIA case file, and I've reviewed everything that the interagency, not I, the FBI, that was provided to us.
Would you be willing to look at the CIA file on Jeffrey Epstein?
If there is such a file, and if it has not already been turned over to the FBI will look.
It was classic damage control disguised as duty. But viewers could sense it. Something wasn't adding up. When someone swears to uphold justice and then dodges the truth, people notice. The committee members pressed harder. You said the files were released. Which ones? What's missing? Every question was an open door, and every answer shut it again. There were apologies for not hearing, corrections that led nowhere, and legal phrases so dense they felt rehearsed. But behind all the talk of sealed documents and procedural limits, one truth started to emerge: the gap between what the public was told and what the agency actually holds. And the moment that gap appeared, the room shifted from inquiry to confrontation that he leaned on a familiar excuse. Rule 6E, the law that protects grand jury material. Most viewers don't know it by name, but they've heard it before. It's the phrase officials use when they want to sound lawful while saying nothing. The rule shields some evidence from being released, but not everything. Witness interviews, seized records, and internal reports don't fall under it. Lawmakers knew that. That's why they kept pressing. So why can't those documents be shared with redactions? His answer? We've released everything legally allowed. But if it's legally allowed, then why hasn't the public seen it? As he kept repeating legally allowed, a pattern emerged: confuse, delay, deflect. The public wants answers. The bureaucracy gives process. Yet when the questions turned to specific evidence, the story grew stranger. Thousands of videos reviewed. Tens of thousands of images examined. Most of it, he claimed, was illegal content that could never be released. No one disagreed with protecting victims or shielding explicit material. But that wasn't the issue. Lawmakers weren't asking for that. They were asking for the rest. The financial records, the travel logs, the interviews, the parts that could show who knew, who paid, who participated. That's where the real story might live. He insisted there were no other relevant videos. None that implicated anyone else. But almost immediately, members of the committee cited investigations and victim statements saying otherwise. One document alone reportedly listed over 20 men, powerful figures across banking, politics, and entertainment. The response? Those claims weren't credible. It was the phrase that has haunted every institutional cover-up. Not credible. What makes a survivor's testimony credible? The answer often depends on who's being protected at that moment. The questioning changed tone. The legal back and forth became personal. A representative who had served as a prosecutor looked directly at him and asked why witness interviews, known as FD 302s, were still sealed. They aren't grand jury material. They can be redacted and released. He brushed it off again, claiming they were under protective order. But when pressed on which court issued that order, the response was vague. Another reference to ongoing review. That's when the frustration boiled over. You're hiding the files, the representative said. You're part of the cover-up. The room went silent. Even those who'd been cautious realized how extraordinary that accusation was. Then came the turning point. The hypocrisy clip. Years earlier, long before taking office, he'd gone on camera calling out the same agency he now leads. His words had gone viral. Put on your big boy pants and tell the public who the predators are. At the time, He accused others of hiding behind bureaucracy, claiming the list was under direct control of the Bureau's director. It was bold, defiant, moralistic. Now, sitting in that chair, facing the same demand, he was giving the same evasions he once condemned. The contrast was devastating. The man who shouted for truth had become the man defending secrecy. One lawmaker played the clip right there in the chamber. His younger voice filled the room, fierce and certain. The silence afterward was almost cinematic. When asked why he'd changed his position, he leaned forward, tightened his jaw, and began a long, defensive explanation about court orders and jurisdictional limits. He even cited previous administrations, claiming they had the same chance to release the materials and didn't. But that argument only underscored the issue. If every administration passes the responsibility to the next, accountability never arrives. Then came the meltdown. Voices rose. Accusations flew. You said these files were under your direct control, so why not release them? Because I won't break federal law to satisfy your curiosity. The exchanges got sharper, faster, louder, each side accusing the other of hypocrisy. It stopped sounding like a hearing and started feeling like a trial. For the first time, his composure cracked. He lashed out at the committee, accusing them of political theater, of chasing sound bites for social media. But that only made things worse. Because if you're telling the truth, you don't need to insult the people asking for it. And then one question cut deeper than all the rest. Have you personally read every file? There was a pause. Then, quietly, he said no. For a moment, the room froze. The head of the investigation, the person with the authority to end speculation once and for all, admitted he hadn't reviewed everything. That revelation landed like a punch. Because if the person in charge hasn't seen the evidence, who's actually ensuring justice? The representative followed up. Then how do you know what's credible and what's not? No clear answer. Only the usual phrasing about teams, agents, and ongoing reviews. It was a bureaucratic blur meant to sound official while meaning nothing. And when you strip away the jargon, what remained was alarming. Decisions being made by people who might not have even looked at the core material themselves. Why now the pattern was unmistakable. The legal shields weren't about what couldn't be done. They were about what leadership chose not to do. Courts don't open sealed records on their own. Someone has to file the motion. Subpoenas don't issue themselves. Someone has to sign them. The refusal to act isn't just legal, it's political. Every "we can't" really means we won't. And that distinction is what drives public outrage. As the hearing closed, the conversation turned toward procedure, grand jury secrecy, sealed warrants, and jurisdictional overlap. But beneath the technical language lay a human story. Survivors who had waited decades for accountability, who had told their stories again and again only to see them buried under red tape. It's not about documents, it's about dignity. Each unsealed page represents a person who deserves to be believed and a system that failed them. The truth is that secrecy, when stretched too far, stops being protection and becomes obstruction. Not all files need to be dumped online, but transparency doesn't require chaos, it requires courage. Redact the names of victims. Remove private data, but show the public what was actually investigated and what wasn't. The FBI has the power to ask the court to unseal non-sensitive material. The Justice Department has the authority to review the scope of earlier deals. Congress has the ability to subpoena. The question is no longer whether they can, it's whether they will. And that's why this hearing mattered. It wasn't about one man's reputation. It was about the line between accountability and loyalty. When someone in power refuses to answer the most basic questions under oath, it tells the public that some truths are still too dangerous to confront. That's not just a legal issue, it's a cultural one. Because once people believe the system protects itself more than it protects them, trust begins to collapse. The cameras shut off and the room emptied. One feeling lingered: unease. The audience watching at home could sense it too. They didn't need to be lawyers to understand that something vital was missing: clarity. Why can't certain documents be shown? Who decided that? And what's being done to challenge those decisions? Without real answers, every explanation sounds like an excuse. But here's what can happen next. Congress can issue targeted subpoenas to force those records into the open. Independent inspectors can review how evidence was handled. Courts can be petitioned to release redacted witness statements. These aren't hypotheticals. They're steps that have been taken in other cases. The difference is whether leaders are willing to take them now. This moment, uncomfortable as it is, offers a choice. Keep letting secrecy breed suspicion, or use transparency to rebuild trust. Real oversight doesn't happen on camera, it happens afterward, in filings, in motions, in public accountability. And it begins when ordinary people demand it, because the truth is this: institutions don't correct themselves unless we make them. Every headline, every leak, every document release starts because someone refused to accept "we can't" as an answer. And that's what keeps the story alive. That if you've watched this far, you're already part of that effort. Don't stop here. Follow the filings. Support the journalists and survivors who keep pushing for disclosure. Share this video with someone who only saw the headlines. And most importantly, subscribe so you can stay with us as we track what really happens next, when the motions hit the courts, when new files surface, and when officials are finally forced to speak plainly. The truth doesn't fear sunlight, but power often does. Keep watching, keep questioning, and together we'll bring the story into the light. Subscribe, like, and stay tuned. This fight for transparency isn't over. It's just getting started.